My name is Amanda Strainis. I'm a partner at Conn Maciel. I've been there since 2014 when the law firm started, and prior to that was in private practice, also focusing on occupational safety and health law. I got my start in the area of occupational safety and health law immediately after law school by going to the Department of Labor, where I was a political appointee and started off in OSHA and then moved over to the solicitor's office focusing on occupational safety and health, so OSHA and MSHA. In private practice, represent a full variety of clients, clients from trade associations to individual employers, and deal primarily with OSHA issues. That's anything from compliance assistance to enforcement defense, interpretation letters, and occasionally get involved with other agencies that have a connection to OSHA, kind of the alphabet soup of Washington, D.C., such as the Chemical Safety Board, CSB, EPA. Their RMP regulation is based off of OSHA's PSM regulations. At this point, I'm going to turn it over to Kate, my partner, she can introduce herself and kick off the webinar.
We're happy to be back with you again. As Amanda said, we have moved this webinar back a few times by numerous months because we continue to wonder what exactly we're going to tell you today. You'll learn as we talk through what we're seeing here in Washington, D.C., that there's an awful lot left to be figured out. But we're reading the tea leaves as best we can, and we do have some data from which we can extrapolate and make some judgments and provide, I hope, some insight into what we might expect in this administration as time moves forward. Just a quick introduction of myself. Those of you who join our webinars regularly don't need to hear this, but I've been practicing in the OSHA area for an awfully long time. I'm an environmental lawyer as well, but my favorite part of my practice is in the OSHA field. I have a particular expertise in OSHA rulemakings, stuff that happens here in Washington, D.C., and in particular chemical rulemakings. I've certainly been involved, I think, in every one of them over the last 20 years. I also, spend my days representing industry and business in enforcement actions that OSHA brings, and provide regulatory compliance counseling to our clients here at Conn Maciel Carey. So enough about me. Let me move on and let me just outline for you what we expect to talk about today. We don't think this webinar will run too awfully long for the reasons that Amanda and I have stated, that there's a lot more to come in terms of figuring out what we'll see in this Trump administration. But we do think we have enough data to talk to you today for maybe a little bit less than an hour here. First of all, we want to start out by talking about the Department of Labor itself, the positions that have been filled, including most importantly, of course, the Secretary of Labor, who is Alex Acosta, as you all know, I'm sure, and what we think that means for what will happen at OSHA. You all are on the phone because you're interested in OSHA. But we think the umbrella, the Department of Labor, and the leader at the Department of Labor, is going to have a huge impact on what we see at OSHA. So we'll talk a little bit about Secretary of Labor Acosta and what we expect there. Two, we'll talk specifically, of course, about OSHA, the leadership, how it's shaping up, what we're seeing so far, and what we might expect. One of the key insights that we have in terms of what we can expect out of OSHA is the regular regulatory agendas that OSHA issues. They come out, that are issued for all agencies, but we focus, of course, on the OSHA rules that are identified as where the agency will focus its resources. Basically, what is OSHA planning to do in the way of rulemaking? There's sort of, if you think of the OSHA world in two parts, there's rulemaking and then there's enforcement. So the regulatory agenda gives us insight into the first component of the OSHA world, which is what is OSHA going to do in terms of rules. And that can give us insight into what OSHA is going to deregulate as well as regulate. So we'll talk about that. And then we'll talk about what we're seeing in enforcement, what we thought we might see, and how that stacks up to what we're actually seeing as a predictor of what might come. And then finally, we'll wrap it up with Amanda talking a little bit about the OSHA Review Commission, the changes that have occurred there, who's in charge, who's new, and what's new. And so then hopefully we'll have a little time for questions. Okay, so let's begin. First, the Department of Labor Leadership. We try to keep these things a little light, and so we thought it might be useful to start out by talking about who's not in charge of the Department of Labor as an insight into who is in charge. I think that it is actually, frankly, probably one of the most insightful and telling points that we can make about what this Department of Labor will do to talk about who's not running the Department of Labor. As you all know, Trump's first choice for Secretary of Labor was Andy Puzder. Mr. Puzder ultimately withdrew his nomination because it became clear that there was just not going to be sufficient support or votes in the Senate to obtain confirmation. And so he withdrew from the nomination, and Trump, after a little while, found Alex Acosta to replace him. Now, the difference between these two men is stark. First of all, I think it's obvious, right, that Trump's first choice was Andy Puzder. Andy Puzder he's a lawyer, but he's primarily a businessman. He's a white male businessman primarily. Secretary Acosta is the first Hispanic member of Trump's cabinet, and he is a lawyer who has spent a lot of years practicing. In fact, he's a Washington insider in the sense that he has held multiple positions. He has been with the Bush administration, Bush II. He was confirmed by the Senate 4 different times, including this last time as Secretary of Labor. So he's been around for a long time in the Washington, D.C. sort of Republican establishment. He was nominated and confirmed and ran and served as an NLRB member for about 8 months under Bush II. He was the head of the DOJ Civil Rights Division for about 2 years under Bush II, and he was U.S. Attorney in Southern District of Florida prior to being nominated for Secretary of Labor position. He, interestingly, unlike Puzder, who could not, couldn't gather the support to be confirmed by the Senate, Secretary Acosta, nominee Acosta, received not only party line vote, he was party line vote coming out of committee, but then in the full Senate confirmation hearings, he received some Democratic support. The vote in the end was 60-38. So he got some Dems to support him. And I think that's another sign of the differences between these two men. I guess ultimately when you sort of stack it up and try to do an analysis, what we see is a businessman like Trump versus a lawyer like Acosta, and what we see is maybe a businessman in the Trump style as opposed to, say, the Tillerson style. Less institutionalized, less mainstream, and Acosta being more mainstream and more part of the institution. So, you can only take that so far, but we wanted to kind of give you some insight about what we think about Acosta based on, based on the first choice for Secretary of Labor. The other sort of, I guess, important insight that we have to share is that it's pretty clear when you look at the Department of Labor. I mean, we are we are over a year into the Trump administration, and although we do have a Secretary of Labor, we have essentially, a pretty empty house over there. We have put a chart together that shows you that there are 5 confirmed positions out of the 14 positions that fall below the Secretary of Labor at DOL. All right, so we've got 5 positions that are confirmed, but we've got 5 that we don't even have a nominee for yet, and then we've got 4 that the President and White House has nominated someone to fill, but it's pending before the full Senate, so we don't have those positions confirmed. So essentially, Alex Acosta is operating without anywhere close to a full House to move the agenda forward. Bottom line, I guess we would sum it up by saying that we would expect that what we're seeing so far is that Acosta is likely to be more moderate and more tempered than what we might have had under Puzder. One of the key insights that we have, and then we'll start talking specifically about OSHA, but one of the key insights that we have about Acosta is not us reading the tea leaves. It's something that Acosta wrote himself. Last May, Acosta had a op-ed appear in the Wall Street Journal that it's worth, for those of you who are, sort of follow this on a daily or weekly basis, it's actually worth reading. There's a short article. It was published May 22nd, and I think it's so helpful in understanding who Acosta seems to be that I'd like to at least just read a couple of sentences from it, because to me it's sort of key in understanding this person. The point of the article is that even with a deregulatory agenda, which is certainly the Trump agenda, the regulators have to follow the law. So you can't just instantly deregulate. There was an effort right out of the box by the Trump administration to deregulate. In the area of labor law anyway, we've got a man in charge who's saying even if you're trying to deregulate, which is a valid proposition and makes good sense in a lot of ways, and he writes about that in this article, he says, though, that you have to be careful about how you do it. And what he says is, Washington must first and foremost follow its own rules. This means federal agencies can act only as the law allows. The law sets limits on their power and establishes procedures they must follow when they regulate or deregulate. He then cites the Administrative Procedures Act, and he basically says that regulations are akin to power they're very powerful things. They're like statutes, like laws. And before an agency can regulate or deregulate, it must generally provide notice and seek public comment. Point being, there is not going to be an immediate rush to deregulation that is done outside the rule of law. We will see deregulatory efforts, certainly, and we'll talk about that in a few minutes. But we know that it's going to be done in a careful manner, and it's going to be done pursuant to the Administrative Procedures Act. So that is the umbrella under which OSHA sits. Let me turn it over to Amanda so she can talk specifically about what's going on at OSHA.
Perfect. Thanks, Kate. Drilling down a little bit, now we've got the Department of Labor and the leading official there, and drilling down a little bit to be more OSHA specific, let's talk about what's going on at OSHA. The highest ranking official at OSHA is the Assistant Secretary. The individual who's been nominated for that position is Scott Mugno. He comes from the corporate safety side of the world, and he's been a VP at FedEx Ground for approximately, I think it's under 10 years, maybe 6 or 8 years. And he's had an interesting process with regards to his confirmation. I went back and looked at the Senate records, and I thought this would be interesting to just show you the gauntlet or the process that nominees are going through to get confirmed. It's, in my experience, fairly unusual. He started his confirmation process, started the public aspect of his nomination process on October 30th, 2017. The President issued a press release, designated Mr. Scott Mugno as his selected nominee to run OSHA, and then shortly after sent his nomination over to the Senate, where it was referred to the HELP committee that has jurisdiction over OSHA for consideration and review, and ultimately a vote out of committee. He had his hearing on December 5th, 2017, along with two other nominees, one from the Department of Education and one the individual who would lead the Bureau of Labor Statistics. After that, he was voted out of the committee on a party line vote on December 13th, where he went with a variety of other nominees to wait for a full Senate vote. That Senate vote did not happen before the end of the before Congress broke for Christmas, so his nomination was returned to the President. It's a little unusual for the nominations to be returned to the President. Usually they're carried over from one congressional session to the next, but since there's so much tension in Washington, D.C. nowadays, very few of the nominations were held over. Most of them were returned back to the President. So as a result of that, he had to go back and do several of the steps over. His nomination had to be resubmitted to the Senate and the HELP Committee, and the HELP Committee had to vote on his nomination again. That last step, January 18th, 2018, the committee did successfully, his nomination made it out of the HELP Committee, passed, and so now he's back in the same position he was in December, waiting for that full Senate vote. Big question on when that's going to happen. There's, a lot of people that have speculated on when that might happen, but it's really hard to tell. It's up to when Senator McConnell brings it to the floor, and when the Democrats signaled that they will not require 30 hours of debate, even though that's not been particularly tagged with this nomination, several other nominations. So a variety of factors waiting for a full Senate vote. Just to give you some perspective on how this process is taking a little bit longer than it has in the past, the previous Assistant Secretary, David Michaels, who served under Obama, he was in place the first year of the administration. I'm not sure when his nomination happened, but he was there in December of 2009. So, 3 or 4 months between when he was announced and when he was actually in his chair at the Department of Labor. Previous to him, and I'm just talking about assistant secretaries in the first assistant secretaries after an administration change. John Henshaw served in Bush number 2, and he was nominated and confirmed within 6 or 8 months of the president taking the White House. So just really taking a lot longer than we've seen in previous administrations. If you had to draw a flow chart for the process that Mr. Mugno's gone through, it would not be a smooth progression. There would be some arrows going back and forth and not an easy chart to put together. So just to give you an idea of what's going on, more details about Scott Mugno. He, as I mentioned before, when he was nominated, he was serving at FedEx Ground's VP of Safety and Sustainability, where he oversaw quite a few employees, workplaces, and trailers. He was an active participant in many safety organizations, very involved with the Chamber of Commerce, as well as some organizations focused on transportation safety. As a quote from the the White House indicated during his nomination, very strong leadership, was recognized internally for that at FedEx. And prior to his role at FedEx Ground, he served as a corporate safety director at FedEx Express and was a practicing regulatory attorney and an RB JAG Corp attorney. Quite a bit of experience in the safety and health community in different roles. Definitely a departure from what we saw in the Obama administration. David Michaels came from George Washington School. He was a teacher, a tenured professor. And so definitely a different perspective from being on the ground and actually trying to implement safety and health measures. As I mentioned before, the White House's press release when he was announced as the nominee on October 30th, 2017, recognized his work in safety, the field of safety and health, and also his honors with regards to leadership. So looking to be a strong leader. Since Scott is not currently in the position of Assistant Secretary, typically the candidates or the candidates who are nominated do not show up at the Department of Labor until they receive their full Senate confirmation. In lieu of that happening, the highest-ranking political official at OSHA is Lauren Sweat. He is the Deputy Assistant Secretary of Labor, who has the title of Acting Assistant Secretary. Typically, individuals who are not confirmed by the Senate tread a little bit more lightly, not going to make any broad program changes, and I think she stayed with that typical standard. Just a little more information on her. She actually came down a couple blocks from her position where she was at the House Education and Workforce Committee. That's a committee that has jurisdiction over OSHA and worked on quite a few of those issues. She was there for approximately 15 years, and before that she was at the Associated General Contractors in Washington, D.C. At their national headquarters. To date, went back and was looking for some public speeches or comments that she made, and there's really not a lot of that in the news. She's not gone to Capitol Hill to provide any public testimony on OSHA's path forward or discussions about budget, and her comments have primarily been limited to press release quotes, speeches to trade groups, and brief comments at alliance ceremonies. So haven't gotten a ton of insight on what her perspectives are, and likely due to the fact that she's treading light as the Acting Assistant Secretary of OSHA. Also to talk about some other personnel changes at OSHA. There has been quite a few retirements in the career leadership ranks. The Deputy Assistant Secretary, Dorothy Doherty, who was in the position for several years, departed over this summer, and that position still has not been filled. They've had a number of rotating senior officials filling that position, kind of a trial period, and also to provide help to the front office. We've also seen some regional administrators retire within the last year. The Denver regional office is currently without leadership, and I believe that there's one other one that escapes the tip of my tongue at this point, but those are now filled by acting administrators. We could also potentially see some directorate heads and some other senior folks departing from the Department of Labor. No such announcements at this point, but would not be too terribly surprised. And we've also seen a lot of retirements with the area directors in charge of the area offices. Wichita, for example, had an area director who retired and has been going through a rotation of different acting area directors, and I learned last week that they might have selected a candidate to fill that. I've not confirmed that, but it looks like they have moved forward on making a hiring decision there. It's unlikely that they will make hiring decisions on the Deputy Assistant Secretary and regional administrators until the Senate confirmed nominee is in place. Usually they leave that up to their discretion, looking for so that they can build their team and have influence on who is selected for those positions. Some other changes that happened within OSHA within the past 6 months. There's been a transfer of OSHA HR duties to the general office at the Department of Labor, who works with all agencies with regards to HR, specifically recruiting. As Kate will talk about, I believe, there's been a decrease in staff since this administration took effect. And there was a hiring freeze at one point, but also just there was some folks thought that it had to do with the HR duty, so that was moved over to OSAM. So that took a number of folks out of the OSHA directorate and put them in a new one. As mentioned, we have seen a drop in staff since the Trump administration started. It could, largely due to a hiring freeze, which was in place for the first 6 or 7 months, has been lifted with regards to compliance officers, and they are actively recruiting new compliance officers to fill those that have left. through attrition and get their numbers back up. Actually looking to increase the number in the budget proposal for fiscal year 2019. I think they are looking to add something like 40 to 50 new compliance officers that would focus on OSHA compliance in the field. Those would be spread out throughout the country. And then just some hard numbers with regards to the number of the staff number that's gone down through this administration. I believe this was for the first 9 or 10 months that there had seen a drop of 119 fewer career staff, which is a pretty dramatic decrease when you're dealing with an agency that has national jurisdiction and a little over 2,000 employees. Turning it back over to Kate now.
All righty. You know, Amanda has shared some important information, we think, about, you know, the staffing at the agency and who's in charge and who we expect will eventually, maybe, hopefully be in charge. But what I want to talk about is, okay, so what have we seen so far, even without a confirmed Assistant Secretary of Labor running OSHA? There is an acting Assistant Secretary, as Amanda's pointed out, and some activity has occurred, obviously, over the last number of number of months. So, is what we've seen so far? One, let's share that with you so you know what's happened. But two, is it a predictor of what we might see? And just before I talk about the specifics, let me just sort of set the backdrop for you. You know, parties change. Elections have big impacts, right? And this one certainly, one would think, was a real, true, seismic shift in what the Washington D.C. and the leadership in Washington. At DOL, as we said, we now have this Secretary of Labor who might be considered more like a Bush appointee, perhaps, than a Trump person. But so if the landscape is on one extreme, you've got sort of, what we expected of a Trump administration. Remember, we had Steve Bannon out there saying that, there is going to be essentially a deconstruction of the regulatory state. We are going to dismantle and deregulate so business can thrive unimpacted and unburdened by regulation. That's one end of the spectrum. On the other end of the spectrum, we had a progressive Democratic administration that was, I would say, if you ask David Michaels, he might say, pushing the envelope in an effort to try to aggressively regulate American workplaces. And he worked hard with some, what I think everyone would say, some successes and some failures to develop a regulatory structure that the Obama administration thought would be protective. It may be, in the end of the day, that we end up sort of in the middle, more like a Bush administration where there's a minimalist approach as opposed to an aggressive, novel, push-the-envelope approach, but not a complete deconstruction of, the regulatory state of the OSHA world. And again, it's too soon to tell because of the empty house and because of the lack of a leader at OSHA, but a confirmed permanent leader at OSHA. But it seems to me that what we're seeing from the actions that have happened so far, at least key sort of significant actions, that it is in fact a mixed bag. We're seeing some continuation of what was happening under Obama, and we're seeing some signs that there is going to be a more minimalist approach, deregulatory approach. So here we go. What have we seen so far? One, we have had the agency announce and inform the public that they are going to engage in a notice of proposed rule. They're going to engage in rulemaking to revise the e-record-keeping rulemaking standard. Now, this webinar is not about the e-record-keeping rulemaking standard, but we've had discussions about that on our webinars in the past, and we could fill a whole hour talking about e-record keeping. It essentially has two major components. The component of the rule that requires the submission by hundreds of thousands of employers of your traditionally privately held OSHA 300 log information, injury and illness log information, and then the anti-retaliatory component of the rule. What we know is that that was highly controversial. Both components of that rule were promulgated, of course, under the Obama administration, and both were highly controversial. We know that this administration has told the public that it is going to revise it, but what we don't know is exactly which component and exactly which way. Our prediction, or I guess I should say my prediction, is that this thing is not going to be completely dismantled. At least there's no sign that the agency is going to completely unravel and dismantle the new e-record keeping rule. But it is going to make changes. And we've already seen, although the actual proposed rule has not been issued yet, we have seen some signs of what might happen. First, we know that the agency is actually engaged in a reverse course on one aspect of the e-record keeping rule, at least, which is the use, the sharing, making public of the injury and illness data that has been collected. Let me just give you 2 minutes on background. As many of you who've tracked this may know, the e-record keeping rule required small employers, I think 20 to 249 employees fit into that category, who were in high hazard industries to submit 300A annual summaries of their injury and illness logs. It required larger employers, regardless of high hazard, 250 or more, to submit first the 300As and then beginning this coming summer, the OSHA logs themselves, the 300 information, and the specific 301 incident information. All right, two big things have changed. One, OSHA, it looks as if OSHA is going to, for the large employers, 250 or more, not require the 301 and 300 injury and illness information to be submitted. Rather, it looks as if the only information that the large employers are going to have to submit is what they already were required to submit this past December, which is the 300A information. Two, as I started to mention, bullet number 2, OSHA seems to be changing course on the sharing of that information with the public. That information under the Obama administration, we understood, would have been put up on their website, on the agency website, for anyone, unions, competitors, employees, anybody, anyone to see. Historically, that information was collected, required to be collected by OSHA regulations, 1904, but was not required to be shared. Not only is it not up on the website like we expected it would be had there been a Democrat in the White House, but we also understand that there have been information, FOIA, that have been submitted because as of December, OSHA did collect information from 214,000 employers, 300A data, right? So OSHA's got a whole slew of injury and illness data, and FOIAs have been issued, I think, from Public Citizen, and to date OSHA is refusing to turn that data over on the theory that it is protected under the active law enforcement FOIA exemption. So that's certainly a change of course. But we do not expect the whole rule is going to go away. more to be seen on that when the notice of proposed rule comes out. Chemical rulemakings, what's happening there? Well, we're not seeing any new new chemicals being identified for the development of a comprehensive health standard. That was certainly a major effort of the Obama administration. There was a recognition of the incredibly small number of comprehensive chemical standards compared to the number of chemicals in the workplace. I think there are 29 comprehensive occupational health standards. There are 8,000 to 10,000 chemicals in the workplaces. Under the 7 or so years of David Michael's tenure at OSHA, he made all kinds of efforts to try to get new PELs and new standards in place, but really to no avail. We're not seeing any such effort right now anyway to develop new PELs, new standards. However, the two chemical rulemakings that had been ongoing at the point of, during the Obama administration continue. We have silica and beryllium. Silica, a major chemical impacting, I don't recall the number, but I want to, a huge swath of American industry impacted by the silica regulation. That regulation was promulgated under Obama, but it was challenged, in court, D.C. Circuit, by industry. We saw for a little while there, or at least there was speculation for a little while there, that the agency might withdraw its opposition to the challenge, meaning, let's let go of this silica regulation. But to the contrary, not only did the agency not withdraw its opposition, it fought vociferously on behalf of the standard that was issued under the Obama administration that was so controversial. Not only did it fight vociferously, it actually prevailed, and a very significant victory in the D.C. Circuit was won by the solicitors on behalf of the on behalf of OSHA in the silica rulemaking a number of months ago. And so that rulemaking was defended, and it is now secure, done at the hands of the Trump administration. Now, having said that, we know that OSHA is also working with, I believe, in particular in the construction industry, construction stakeholders, to, I believe, cooperatively develop a possible guidance or revision to that standard that will make it a little easier to comply with the standard in terms of implementation of engineering controls. So we're seeing a standard that was put in place, but maybe some things are going to change around the edges to make it a little bit more employer-friendly, if you will. Another example of the agency, and then just a quick word on beryllium. Beryllium was issued under the Obama administration at the very, very tail end of the Obama administration, challenged by multiple petitioners in various courts, consolidated in the Sixth Circuit, in the Eighth Circuit. We have OSHA actively engaging with the petitioners in settlement discussions. More to be seen on where that all ends up, but we do have the agency not throwing in the towel. They're defending the standard, but they're working, it looks like they're working at least with some petitioners to develop revisions to the standard that might make compliance somewhat easier. The Standard Improvements Project. This is something that began in 1995 under Bill Clinton. It is an effort to streamline, update regulations that are on the books. Regulations are promulgated and then they sit there forever, essentially. There's technology developments, modernization, and a real need to improve, update regulatory standards. So that's what this SIP process is designed to do. We're on SIP number 4, and one sort of startling thing that we've identified in SIP number 4 is the SIPs are for relatively non-controversial changes, updates essentially, driven by technology in large measure. We have one SIP proposal to eliminate the term unexpected energization from the lockout-tagout standard. That could have significant impact on the scope of the lockout-tagout standard, with a significant broadening of the standard. Essentially, it would, theoretically anyway, potentially eliminate a key threshold for application of the lockout-tagout standard, the unexpected energization of component of the threshold that that renders the standard either applicable or not applicable. And there was a case that was issued in the GM Delco case where the court rejected OSHA's position that Lotto applied to the situation because it was not unexpected energy that was at issue in that case. It was foreseen and known to the employee that there would be an possible energization of this machinery, and so the court said in that case that Lotto does not apply. We see this SIP proposal as possibly impacting that issue, and so we're watching it carefully. But it may be an expansion of Lotto, which would be a sign that this Trump OSHA is not entirely deregulating. On the other hand, paring down the regulatory agenda. So we're at 144, so I'm going to kind of move pretty quickly through this. But so regulatory agendas are these, as I mentioned earlier, I think these biannual documents that are issued that identify the rulemakings that the agency is going to identify. We pore over them when they come out. One thing that we've seen that the new regulatory agendas look like under Trump, there's now a new data field that's been added to track whether a regulation that's being proposed is regulatory or deregulatory in nature. So as Alex Acosta has pointed out, under the rule of law, even when you're deregulating, you've got to go through a rulemaking process to deregulate, to get that rule off the books or to change it to make it less onerous to employers. And so we now have a way to track whether a regulation is adding burden or lessening burden, theoretically anyway, to employers. Long-term action and active items are facing increasing scrutiny in the sense that the agencies have been asked by the Trump administration to remove from the regulatory agenda entirely items that have had no update in the Federal Register in the last 5 years. So if they're sitting there on the Federal Register, on the regulatory agenda in the, sort of pending, if you will, category, Trump administration is saying, get rid of them. You're not doing anything with them. Take them off the books. Similarly, they're saying take off the books action items where you expect no action in the next year. So what we see as a result of that guidance from the White House is we see in the area of OSHA, these items have been removed from the regulatory agenda. So OSHA had been planning to do a whole bunch of stuff that were identified, plans identified under the Obama administration. Workplace violence, for instance, there was huge pressure on the Obama administration to develop a workplace violence standard. Right now there is none, and now that has been removed from the regulatory agenda. We're unlikely to see a workplace violence standard. So deregulation. However, moving through the slides, we put a slide in here on e-record keeping. I think I've essentially covered most of this, so maybe there's a little more data on the slide you can take a look at after the presentation, but I think I've sort of covered it. So I guess in sum, if you will, what we're seeing on the rulemaking front is a little bit of a mixed bag. Some initiatives, some scaling back. What are we seeing on the enforcement side? All right, well, what everyone I think expected to see on November 6th when Trump was elected was a major shift in the enforcement philosophy at the agency. What was expected was that there would be a serious scaling back of an enforcement-heavy or an enforcement-aggressive philosophy, and that would be sort of the slack there would be taken up, or there'd be a balancing with more emphasis on compliance assistance. I mean, that's the typical sort of Republican-Democratic approach. Enforcement heavy on the Democratic side, compliance assistance on the Republican side. We expected that would happen because we had a Republican, and not only a Republican, but Trump in office. We expected that there would be a revision of enforcement policies that tend to inflate civil penalties, right? So OSHA has some wiggle room or some discretion in the development of its enforcement policies. And one of the ways that OSHA can increase the limits on statutory penalties for OSHA violations is to use its prerogative to, for instance, create an egregious case policy where if something falls into an egregious case, you can multiply the number of the penalty by the number of impacted employees. That's a way to hugely multiply the fine associated with a particular citation. So the agency was novel in development of policies. We expected to see those revised so penalties would be lower. We expected that we would see a retiring of a number of national, regional, or local emphasis programs. And we expected to see pretty serious budget cuts to limit enforcement. What are we seeing? Again, it's early. Again, there's an empty house. But what we're seeing is, at least currently, we have the leaders on the enforcement side, the leaders of the agency, Tom Galassi, who's the director of the Directorate of Enforcement, and Rich Mendelson, who's the now acting Deputy Assistant Secretary at OSHA, the non-political Deputy Assistant. We have both of them making statements that indicate that we're not going to see a complete, lay down in terms of enforcement. OSHA will balance enforcement and compliance assistance, but will not back away from our enforcement mission. Now, that sentence could have ended at balance enforcement and compliance assistance, but it didn't. There is still an active or a recognition that there's a real role for enforcement in the OSHA world to protect workplaces and workers. Enforcement and compliance assistance aren't mutually exclusive. In fact, they're complementary. They're tools to accomplish our mission of workplace safety. Every indication that enforcement is here to stay. What are we seeing in the area of enforcement? The emphasis programs, the national emphasis programs. We have a slide listing those. We have, in addition to the 9 national emphasis programs, we have 150 local and regional emphasis programs. We are not seeing any sign that those are being shed or eliminated. As time goes on, obviously those change, but there's been no indication whatsoever from Lauren Sweat or any of the top leaders at the agency that those are going away. We have an indication, if we we've looked at pretty carefully at the President's proposed budget for 2019 and what he did in 2018. We see an identification of certain areas where we expect new material to be issued by the agency. Now, these obviously are not new rules, but OSHA has indicated that we expect to see new technical materials on noise, that's hearing conservation, on fatigue. There was a lot of focus in the Obama administration on fatigue, driver fatigue, worker fatigue, workplace violence. So even though we see a removal of workplace violence from the regulatory agenda in terms of the development of a formal rule, it looks like there's going to be additional activity in the development of materials, guidance materials that OSHA issues on workplace violence. Medical management, another area where it looks like there's going to be some issuance of materials. And OSHA has specifically identified as a priority goal for 2018 the identification and abatement of construction workplaces where trenching and excavation hazards exist. They have a specific goal to abate 1,270 trenching and excavation hazards in 2018 and 1,400 in 2019. That was also an area of high emphasis during the Obama administration. So a clear recognition by this new administration that trenching and excavation in construction are hazardous activities, and there will be continued enforcement activity in that area, we expect. Interesting piece of data. Total federal, and let me just go back one more point about looking at the President's budget. The President's budget had, let's see, we have for $549 million, a budget request basically staying the same. There was not a huge shift, not a downward shift in the budget for OSHA. There was a major cut of $10 million for the Harwood training grants. But interestingly, if you look what the proposal is for the use of that, the $10 million that had been historically used on Harwood training grants, OSHA is shifting that money. $6 million of that $10 million looks like it goes to be reallocated to enforcement programs, with the other $4 million shifted to compliance assistance. So this was not a complete shift to compliance assistance. I think it's, kind of an interesting fact. We have OSHA inspections. What are we seeing? Was it a huge downturn in the number of inspections? Absolutely not. In fact, there was a slight uptick from 2016, which was a full Obama year, the last full Obama year. Remember, this is fiscal years, so the calendar runs from October 1st, I believe, through the following September 30th. So 2017 data does include a few months of the Obama administration. But, certainly we're seeing no huge downward trend in the number of inspections. Civil penalties. The increase, there was an increase in the civil penalties. Now that increase is, driven by law, but we did see them go up again last year. I guess it was just the first part of this year. Just a slight bump increase associated with penalties, but serious and others. And serious go up, about $500 or so, and about $4,600, I think, for the willfuls. So penalties going up slightly. What are we seeing in terms of average penalty per serious violation? Again, some of this data comes from the last few months of the Obama era, but I don't think that accounts for this increase. We're seeing a slight uptick in the average penalty that is being issued. What are we seeing in terms of significant cases? Two important facts here. One, 2017, we saw a fairly significant increase in the number of proposed penalties that hit the significant 100,000 significant penalty mark. So again, consistent with the idea that there's at best a balanced approach, if you're looking, or at worst, depending on your perspective. This is not a total dismantling of the issuance of very significant penalties to employers. OSHA did increase, because of the increase in penalties, OSHA did increase the threshold for a significant case from 100,000 to, I believe, 130,000. Repeat violations, just a word on that. We don't know much yet because the data just is not there for us. But to refresh your recollection, historically, and certainly under the Bush era, we had repeats issued if during a 3-year look back you had a same or substantially similar violation. Under Obama, that look-back period increased to 5 years. So one of the big questions we have not answered yet is OSHA under Trump going to return to the 3-year look-back period? The other kind of key question is OSHA going to treat do the repeats on a facility-by-facility basis? Under Bush, and historically we saw repeats decided and defined based on individual workplaces. They were treated as individual establishments. Under the Obama administration, in order to expand the number of possibilities for repeat citations, OSHA looked at workplaces basically by a corporate family. So if you had one facility violate a lotto standard, and then you had another facility, a sister facility, another area, another state, wherever, in that corporate family with the same or similar lotto violation, OSHA could issue a repeat there under Obama. Question, will they do the same thing under Trump, or will they go back to treating these as individualized facility-based determinations for purposes of characterization of a citation? And finally, is OSHA going to go back to kind of the reactive philosophy they had under Bush, where after a citation was issued, are they going to turn around and come back real quick to do another inspection, or are they going to allow a lot of time to pass? We sensed that there was some data to suggest under Obama there was a more proactive targeting approach that was implemented where there were more follow-ups more quickly. What will happen? And that, of course, can lead to more repeats. And so, what will happen? We don't know quite yet. Repeat violations, the number still on the rise. We're going up in 2017 about 0.2%. So it's continuing to uptick. All right, well, so in sum, bottom line, we can't tell you anything. No, I'm teasing. What we can tell you is there's a mixed bag. We don't think this is going to be, we don't think Steve Bannon would be particularly pleased, but we also think that probably David Michaels would not be particularly pleased either. So that's where we'll leave it for now. More to come. Amanda's going to talk about press releases and David Michaels' regulation by shaming.
Thank you. If any of you have joined any of our previous webinars and listened to our practice group leader, Eric Conn, talk during presentations, he often hones in on this issue. This has been an issue that's bugged him for some time, especially during the time that it was implemented under David Michaels during the Obama administration. This is a quote highlighting the importance and the focus that David Michaels put on press releases. It was a strategy that the previous administration used to shame employers into compliance. Did it work? Hard to tell. But these press releases had particularly nasty quotes in them, often from either somebody, the assistant secretary or the area director. And the key thing, and I think the thing that probably bothered Eric the most, was these press releases were issued at the same time the citations were. And when citations are issued, they're mere allegations that have not been proven. Usually, if you're dealing with another branch like a DOJ, it's just a mere fact that somebody has been issued citations, not with the really nasty press releases that might come after a conviction, but just really unfair painting of employers before they've had an opportunity to defend themselves. So that's a quote from David Michaels in the previous administration's approach to press releases. Since that point in time, and I think a lot of folks in the business community and the regulated employers were very upset with David Michaels' practice use of press releases, that we saw a pretty dramatic change in the Trump administration with regards to press releases. This graphic shows the last 5 years of the Bush administration, the last 5 years of the Obama administration, and then the first months of the Trump administration. So you can see the Bush administration was certainly issuing press releases, roughly 148 per year. Then we go to a pretty high spike under Obama, and we're looking at 463 per year. And then all of a sudden, it just literally stopped. For someone who checks the OSHA website pretty regularly, it was kind of shocking that we did not see very many press releases at all. Literally, there were 2 posted. These are pretty high penalty cases. And then there was a lot of criticism with regards to the new administration's practice on press releases. And there was a review, and we've started to see some more press releases issued. Certainly not at the rate that the previous administration was issuing them, and a little bit more selective. There's not, or at least I haven't identified what the new criteria is. Usually it's the higher penalty cases where there was fatalities involved. But a week or so ago, we saw a press release issued for a set of citations that I think was approximately $14,000 or $15,000 in penalty amount. Not sure why that was issued. It could have been a novel issue that they were trying to alert the regulated community to, but it kind of caught us off guard. In any case, you're not seeing the quotes that David Michaels put into his press releases or encouraged in the press releases during his time at OSHA. So those have gone, but still there is notification regarding press releases, just certainly not at the rate that it was before, and not with the press releases we're seeing now are more matter-of-fact based. Somebody was issued citations, this was the penalty, this is relating to whatever industry. So a few details about that. So there has been a pretty dramatic change with regards to press releases in the change of administrations and under the Trump administration. And then before we end, just a few comments with regards to OSHRC. In case anybody is not familiar with OSHRC, OSHRC is the adjudicatory board that oversees all OSHA cases. So if an employer receives a set of citations and they decide to contest them, the review goes before OSHRC. It's docketed there. You're usually assigned an administrative law judge, and the commission oversees the pool of administrative law judges and then also reviews cases. Usually with OSHRC, the practice has been, there's nothing in law that stipulates this, but it's been the practice that whoever is in the White House, what party is in the White House, gets to have 2 of the seats, and then the party out of the White House gets 1 seat. And that is what we see here. We have 2 Republican previous corporate attorneys in private practice. Heather McDougall and James Sullivan were just recently nominated under Obama. And then we have Cynthia Atwood. So we're seeing a shift in the power at OSHRC. Just a little more detail with regards to each one of these individuals. Heather McDougall was actually the Republican when Obama was in office. She was the one Republican for the 2 Democrats, first nominated back in 2014. She just got renominated this past summer, had her Senate confirmation, and she's good. I forget the number of years that these terms last. I want to say 6, but I'm not absolutely positive about that. She was in private practice doing OSHA defense work before she was nominated in 2014, and back in the early 2000s, she had served as the chief counsel to OSHRC chair, and I think that was Scott Railton. The Democrat is Cynthia Atwood. She's also in her 2nd term, was first nominated under Obama, and then she filled out a term that had not been completed and then was renominated and confirmed. She was a former administrative law judge at the Department of Labor. They do not hear OSHA cases there, but whistleblower cases and some other cases. And then also, prior to that, she was the associate solicitor for DOL's OSH and IMSH division. So the highest-ranking OSHA attorney at the national office, essentially. And then the most recent member and the newest member on the OSHRC Commission is James Sullivan. He comes from private practice. He was out of Philadelphia, and he was just recently added to the commission. This is the first time since April 2015 where they've had a full complement of 3 sitting OSHRC commissioners. Prior to that, there had been no nominations, and it was just kind of a vacancy. They could hear and review decisions, and they could issue decisions if there was agreement between the 2 members on the commission but a lot of times there was not that agreement, and so things waited a long time before they got a decision. Hopefully we're going to see more movement with OSHRC and the review of cases. We're also seeing a push in the Commission to make it more transparent. They have updated their website, doing more postings to the website, announcing ALJ decisions as well as Commission decisions. We've even seen them now start to post on Twitter. We also saw the first argument in nearly 10 years, oral argument that is, which is unusual. I think this is the second one. I've been practicing in this area since about 2004, 2005, and that is the second oral argument that I can recall before the OSHRC commissioners. Big focus on the backlog of cases. Once again, they didn't have a full complement of all three judges, so there was a lot of opinions that kind of lagged around waiting for the third member to get there to break a tie or a disagreement. Going back, looking at their budget for the most recent fiscal year 2019 coming up, they're seeing more cases as penalties have gone up, and they are going to be, or they proclaim to be, focusing on their simplified proceedings and mandatory settlement programs, looking to help alleviate the backlog of cases that are going before trial or go to trial. With the two right-leaning commissioners, for the first time in more than a decade, we're likely to see more employer-friendly decisions. So that concludes our webinar today. We hope you find this information helpful and will join us for our upcoming webinars. Our next one will be in the month of April, and it's going to be on the new silica and beryllium rules, which will be taking effect in the calendar year 2018. As always, we will be following up to all participants with a copy of the Dept slides today. And feel free, if you had any questions, didn't have an opportunity to ask a question or get an answer, we'll be happy to answer them. Please feel free to reach out to either Kate or me, and we're available. Our contact information is on the last slide that you'll be receiving. So we greatly appreciate your participation today, and that concludes our third webinar for the year. Thank you.